What's up, ladies and gentlemen? Welcome to the show. As always, thank you for tuning in. So this is something that happened that a lot of people weren't talking about was the Donald Trump New York civil fraud case. I think they're going to turn it over. I do. I think, and for obvious reasons. But I watched the entire appeals case. It was like a 50-minute video where they went in front of the Supreme Court judges, and Trump's attorneys absolutely nailed this on every aspect. I did record some key parts of the appeals process, and what you could see in this is you could see obviously the prosecution, which is clearly a Democrat, a TDS, a Trump deranged Democrat, pretty much saying Trump he's a fraud. He's always been a fraud. He's committed so much fraud that he has to be held liable, because if the Supreme Court doesn't hold the line here, if they don't draw the line here, then anybody can commit fraud, and so therefore Donald Trump must pay the price. But doesn't really give any reasons why. She cites cases and she goes back to other cases, but every single one of the cases she cites is rebutted. And to be honest, and I wrote some notes, the entire point that the Attorney General's office is making is that these judges, Donald Trump must be held liable to deter future fraud. Because if Donald Trump isn't held liable, then nobody that commits fraud could be held liable, right? That is their argument. Donald Trump's legal team is trying to explain there is no fraud. So I have this article here. Let me go ahead and get this pulled up. I want to show you. So hang on, let me fix something here. So this is an article from the Associated Press. Now, this actually happened on the 26th, this hearing. But I didn't hear anybody talking about it, and the left isn't obviously going to talk about it because I think Donald Trump's good. I think they're going to overturn this. I really do. I think they're going to overturn this. And not only that, but I think they're quite pissed off at at this case being brought to begin with. I think these judges here are pissed off at Judge Engoron. I think these judges are pissed off at Letitia James. I think they're pissed off that this case is even being brought to them because there's just nothing here. There's nothing here, and I think these judges see how damaging this case would be for all businesses in New York City if this is allowed to go through, if this is legitimized. And essentially, and I'm going to play you in a second, Donald Trump's attorney saying, if you draw the line here, there is no line. You're essentially saying that there's fraud when there never was fraud to begin with. And that's what we're going to go through. So I made some video. I watched this entire thing. It's like an hour long. And I have some pieces that I wanted to show you, but I wanted to show you this article first. So New York Appeals Court seems open to altering Trump's, quote, troubling $454 million civil fraud penalty. And it says some judges in a New York appeals court appeared receptive Thursday to possibly reversing or reducing a civil fraud judgment that stands to cost Donald Trump nearly $500 million. One judge called the former president's penalty troubling and wondered if the state's policing of private business transactions amounted to deterrence or mission creep. Exactly. So a 5-judge panel in the state's Intermediate Appeals Court in Manhattan squeezed lawyers representing Trump and the New York Attorney General's office during oral arguments in the Republican presidential nominee's fight to get February 16th verdict overturned. At times, the judges appeared dubious of Trump's side, too. Often judges in appeals court will ask pointed questions of both sides to test their arguments. And that's true. They did ask pointed questions to test the arguments. And the Attorney General's office has they're really relying on the hatred of Donald Trump to try and penalize him for something that should not be penalized. They're trying to draw a line in the sand when there shouldn't be a line. And so the defense team is saying, listen, judges, if you write this line, if you draw this line in the sand, that's it. You're essentially making something that's not a crime into a crime. And when that happens, it's over. You're going to have New York business owners fleeing the state because what just happened was something that's not fraudulent become fraudulent based off of because you don't like somebody. This is a very, very miscarriage of justice, And it makes me sick because it's so damaging to the system. And these are the people that are, supposedly the so-called defenders of justice, the defenders of democracy, but yet they can't see that they're actually the ones that are causing all the damage to our democracy and to our justice system. Let me go ahead and play this part first, and then you could see, I think you could see both sides of the case here.
I'm trying to figure out about the valuation of Mar-a-Lago. I noticed that your expert, Mr. Mons, valued it at over $1 billion. He also said that if it was in the hands of a new owner, club memberships, 500 club memberships could be sold, generating $250 million, and it generates revenue of over $50 million a year in 2022 and 2023. And Supreme Court values it at $18 to $27 million because of restrictions. Do you have anything to say about those restrictions taking it down in value to such an extent?
I'd say two things in response to that. First, the Shubin affidavit directly addresses that. That was improperly kind of disregarded.
He says there are no restrictions on it. He says Shubin says there are no restrictions.
He says you have to interpret, he says the trial court looks at one document in isolation, the deed of conservation. Mr. Shubin says you got to look at all 5 documents, including the historical practice there, to understand what the actual policy is. And for example, they say you couldn't value it as a private residence, but he's been using it as a private residence since 1995, continuously to this day. But the more fundamental point is that valuation, where he relied on a tax assessment, illustrates the hazards to the marketplace as a whole here from having the Supreme Court cite things like Chico Marx in footnote 9 of the summary judgment position, the I know it when I see it standard from obscenity law from Justice Potter Stewart to decide what's a misrepresentation in these statements. When you have expert testimony unrebutted that says these are gap consistent, if we have a system where you can issue perfectly accounting clear and basically statements that comply with gap, and you're held, well, we have another standard. I know it when I see it. That's good. That's bad. People can't do business in real estate. So
Thank you.
thank you, Your Honor.
Oh, I'm sorry. There's another question.
Oh.
Sir, are you asking us to draw any bright line rules as to the contour of the AG's authority under 6312, or are you asking us to scrutinize the evidence that was adduced either at summary judgment with respect to claim number 1 and then at trial with respect to 2 through 7?
The latter, Your Honor. So our argument is on the unique facts of this case, you cannot come to the conclusion that the plain language of the statute was violated. And we argue, obviously, that they raises constitutional questions as well under Grasso and under the excessive fines clause and so forth. We make all those interpretive arguments. But the fundamental point is, if you look at these unique facts on this case, the statute just doesn't cover it. And if it does, it has no limitation.
It's your position that under the facts of this case, 6312 didn't support the taking the action that was taken.
That's exactly right, Your Honor.
All right, so what the Democrats are trying to say, let's just split this up between Democrats and Trump's attorneys, because that's what this is about, because Democrats have politicized our justice system. So we're just going to say Democrats. I'm not going to say AG's office. I'm not going to say Letitia James or Judge Engeron. I'm going to say Democrats because that's what they are. They have politicized our justice system and are using it as a tool to kneecap somebody they don't like, and they don't want them winning the election because that's what's happening. So Democrats in this case are essentially saying that Donald Trump overvalued his property so that he can get lower interest rates and more money. He overvalued his property, that his property was never valued at that much. There's a lot of other stipulations and laws. As you could see, it's extremely complex, which makes the point even further that this is a complex business deal, a complex transaction between two parties, equally complex, equally, I guess you could say, incentivized to make sure that it's right, because either side could lose money. So basically what the Democrats are saying is, hey, we know there's fraud. This is fraud because Donald Trump's always been a fraudster and he's overvaluing his money. And he never would have got those low interest rates and he never would have got that money if he didn't conduct fraud. And we have to do something to Donald Trump or else other people are going to do the same thing. So we have to draw the line with Donald Trump. He must be punished. He must pay this money, or he must be held liable. And Donald Trump's attorneys are saying there was no fraud. Donald Trump overvalued his property. However, The Deutsche Bank, the loaners, okay, the lenders, they knew this. They knew Donald Trump overvalued his property. They add that into their calculation. They add that into their risk assessment. They did their part. The lender, the people that were giving Donald Trump the money, did their due diligence. They did their disclaimer. They signed the papers. They did all that stuff. It gets complex, I know. But I'm saying both parties did their job. How can a third party then intervene and say what you did was illegal and therefore you must pay the price? You broke the law. When there is no victim, both parties were happy. How can then the state or government come in and say, oh, well, we're not happy? Like, well, who the hell are you? They're supposed to represent the so-called people. They're to prevent fraud from, defrauding the public. That is their concern. That is their main reason their main reason for even interjecting into this case is they are protecting the people by, stopping Donald Trump or, if make an example of Donald Trump to deter other would-be fraudsters from defrauding the public. And there is no case. Folks, there is no case. When you listen to the Democrats' argument against Donald Trump, they're citing case law, and there's a rebuttal to every single case law because in those cases, there was actually crimes committed. There was actually fraud. So I can't get into the details of the case. I'm not a lawyer, by the way, but this is easy stuff. All you have to do is watch this one video, and you can see exactly what both sides are arguing. And I'm telling you right now, Donald Trump's lawyers have this in the bag. He answered every single one of the judge's questions, even though the questions were kind of really, really pointed, but he had a perfect answer to it. And when you listen to the answers, it makes way more sense than what the Democrats are saying, than what the Attorney General's office is saying. The Attorney General's office's case is based off emotions, just like everything else, right? Everything they do is based off emotions. We don't like Donald Trump, so therefore he must pay the price. We got to break a few eggs to make an omelet. And if that means you got to draw a line in the sand and that ruins the justice system in New York City and businesses leave and the whole city collapses, then that's what we have to do because we have to interfere in this election. We have to make Donald Trump pay. And the judges are sitting there. They're like, well, there is no crime here. You can't make fraud out of something that with no victim, with no crime. And the Democrats are just like, you have to, though. You have to. It's crazy, man. So let me get back into this, and I think it's going to explain some more. I think I have. Oh, yeah. And by the way, the Attorney General's office is trying to sanction Donald Trump's lawyers. So any lawyer that works for Donald Trump and argues his cases, they get attacked. Whether that's through threat of disbarment. And in this case, the Attorney General's office wants all of the attorneys working this case sanctioned. I mean, I can't see anything more destructive to the justice system than sanctioning lawyers just because they're defending their client. You can't. I mean, Democrats are so dangerous when it comes to this stuff, man. So, because you're defending the fraudster, now you must pay too. It is very authoritarian, very tyrannical kind of power struggle here. But I don't think the judges are buying it, man. This is where the sanctions lawyer comes up. He's trying to defend these lawyers. So here it is. Donald Trump's lawyers are defending Donald Trump. And the Donald Trump's lawyers have to have a lawyer to defend them. This is how crazy this stuff is getting, man.
Good afternoon, Your Honors. Brian Isaac, as you know, I represent the non-party appellant attorneys. My argument is not as sexy as the other arguments, but I think it's a hugely important argument to me as an appellate litigator. I think that the New York State judicial system is the best in the world. I don't think it's better arithmetically. I think it's better geometrically. And I think most of the credit goes to you, but some of it goes to us also. You can't do your job in an exemplary fashion unless we do our job competently. And every single lawyer who practices in New York knows it's not what you get at the trial level, it's what you keep in the appellate division. It is an absolutely horrible idea, in my judgment, to sanction attorneys for making motions for summary judgment in cases where they have to do it to preserve the issue, not only here, Your Honors.
You don't want to take a chance on the appellate court saying, oh, they didn't preserve the issue.
Judge, it's not only here. This is a Trump case. Like him, don't like him, it doesn't matter. This case is a case that definitionally could go to the Court of Appeals. Look at 522B41. Look at Cialina against Erie Preserve. Look at the number of amicus briefs that you had. I couldn't even read them. You have to preserve these issues. And there's one fact that I want to bring to your attention. I know you know it, but we probably should have brought it out in the brief more. You have interest of justice jurisdiction. You can, if you want, decide unpreserved issues. You almost never do it if you don't believe me. Just run my name. Just put Brian J. Isaac, in quotes, within 8, put preserved, unpreserved, not preserved. See how good I've done. I'm not 0 for 5. I'm not 0 for 10. I'm 0 for 3 decades on that. But this court can do it. The Court of Appeals can't. They do not have any interest of justice jurisdiction. They are not allowed to decide mixed questions of law and fact. They can't decide damage issues. They can't decide that a case is against the credible weight of the evidence. How can a competent attorney, and these people are competent attorneys, risk a $440 million malpractice claim by not raising an argument that's a tenable argument? And I'm not going to go over my time because I don't, but I wanted to say something to you. The Attorney General and the trial judge excoriated the lawyers for making a motion for summary judgment on disgorgement at the summary judgment level. One of the cases they rely on is People against Ernst & Young, which you know. Can I read to you what you said? This isn't Brian Isaac. It's not Michael Ross who wrote the brief for me. This is the Appellate Division, First Department. I'm reading it verbatim. Quote, therefore, while the Attorney General does not allege direct injury to the public or consumers as a result of defendants' alleged collusion with Lehman Brothers in committing fraud, the equitable remedy of disgorgement is available in this action. Here's the key point. And it was premature to categorically preclude it at the pleading stage. That's verbatim. That is exactly what these lawyers did. And to be sanctioned for it is just wrong and threatens the integrity of what I think is the greatest juridical system we've seen. You shouldn't allow it.
Thank you. Counsel.
I think it's just sad that you're sitting there defending your client, and then you have to defend your law license, your reputation, your law office, your bar license. Like, what the hell is going on here? Because they filed a motion? No, what this is they want Donald Trump to pay, and anybody that defends him to pay. This is how authoritarian these people are. This is how obsessed they are. How deranged they are. This is Trump derangement syndrome seeping into our justice system. In the beginning, in 2016, 2017, it was just within the voters. The Hillary Clinton supporters, the TDS was strong. But now we have TDS seeping into our justice system. Jack Smith, we have TDS seeping into judges, the appellate courts. We have TDS seeping into our federal agencies. So like this very weird mental disorder that completely consumes people, and it causes them to act irrationally. It causes them to go insane when it comes to Donald Trump. And all of it can be blamed on the media, because when you look into a lot of the stuff the media said about Donald Trump, the lies, which we're going to do in another segment. I want to do a segment based off, the good things Donald Trump has done. But the media has done this to these people. They're the ones that have said Donald Trump came out and colluded with Russia, which was a lie. They're the ones who came out and said Donald Trump did this, Donald Trump did that, which was all a lie. The J6 committee was a lie. The impeachments were a lie. They're all designed to drum up hatred for Donald Trump, and this is the end result. It starts seeping into our federal agencies and our justice system, and now you have laws possibly being created. Okay, you have standards being set based off of Trump derangement syndrome. And I don't know about you, but when it comes to persecuting Donald Trump, the standard is set very low. They're trying to penalize this guy, and there's no victim. There was no crime. You can't have a standard of justice like that. You just can't. And that's the standard of justice Democrats want. And that's what's so damaging. Because what happens when I get brought in front of court? What happens if normal, regular people get brought in front of court and these people have lowered the standard of prosecution, lowered the standard of justice in order to get Donald Trump? Well, that's a big problem. And, I just wanted to make that point, but this is the Democrat lawyer coming up, the TDS deranged lawyer coming up. And I got to say, the judges on this panel, they're not buying it, I don't think. Here, check this out.
So you have 10 minutes on this first.
We're not going through the whole 10 minutes.
I don't know if it's easier, Your Honor. Since we're the appellees, I'm happy to just take the full 15 minutes as the appellee, and that
Okay.
I think that maybe simplifies things. May it please the court, Judith Vale for the New York Attorney General's office. All of the defendants repeatedly
Ms.
violated.
Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners, where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence, where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
This judge is not happy.
And where the victim never complained about any fraud in the transactional losses from it. Because I've gone through the cases which you've cited, and all of them always involved a consumer protection aspect. It involved protection of the market.
Several responses.
And I want to add to his question, and little to no impact on the public marketplace.
Well, maybe I'll take that first, Your Honor, and work.
Okay, essentially what this judge is saying is, before she even gets started, this judge is like, I want you to name one case. Do you know of any case where this has happened? Where you essentially have a complex negotiation between two separate parties. Both of them were perfectly happy. The money was paid. Interest was paid. Everybody left happy. And in fact, the bank, the lenders, said they would do business again with Donald Trump because they made a lot of money. And the judge is asking, has there ever been a case essentially like this, where the state, the government is coming in and saying, oh no, you committed fraud, and you may not think that you were frauded, but you were, and so were the people, the citizens. And she goes into these cases, and the judge says it right there. Every single case that she cites, there was actual fraud, unlike the case that they're arguing right now. And just like the judge on the right, all the way to the right, she's essentially saying, is there ever a case where there was minimal to little to no fraud ever brought? And no, there hasn't. But yet this attorney wants to try and argue her case. I didn't record all of her arguments because they're lame. But you could get a gist of where it's going in the very beginning here.
Backwards, there was absolutely a public impact and a public interest here. There are at least 4 different public harms from the kind of misconduct here. First of all, when deceptively hidden risks are injected into the market, that does hurt the counterparties, and there was harm to the counterparties here. But
so deceptively hidden risks. So essentially they're saying, yeah, the public was affected because there were risks involved that never actually really happened. So who determines what is a risk and what is not? That's one of the problems with their case, man.
it also harms other market participants and the market as a whole because they are not understanding the risks, they are not pricing them in properly, and they are not prepared for what might happen if the true risks come to pass.
So they're essentially arguing they are the arbiters of what's risky and what's not risky, what's considered fraud and what's not fraud. That's essentially what they're saying. So these people were defrauded and they don't even know it. They accepted undue risks and they don't even know what they actually did. That is what they're saying. So essentially what they're doing is they're subverting the power of these two parties doing business. And they're essentially saying, yeah, we're going to determine what's riskful, what Deutsche Bank should have done, and what Donald Trump should have done. You can't do that. That's a private transaction between two private businesses. And the state's trying to come in and say, oh, yeah, but you took a risk that you didn't actually know was a risk. It's crazy, man.
Also, as the legislature made clear in passing 6312, it was concerned with harms to the honest business people who don't do the misconduct and therefore don't get the kind of benefit that they got here.
I suppose you're referring to the fact that Trump received a lower interest rate than he might otherwise have received. But haven't you yourself conceded that the assets were sufficient to get the lower interest rate of the private wealth management direction?
Absolutely not, Your Honor. That is not conceded one bit, and the evidence is to the contrary. If you look at what the Deutsche Bank witnesses testified to, Haig said that the financial strength of the guarantor affects the pricing in terms of the loan. That's in the record at 28167 to 68, and it affects whether the private wealth management group would be allowed to do this deal at all. That's at 28150 of the record. And you have to remember something. As the net worth as the statements were coming in, the Deutsche Bank was doing a stress test. So if without the fraud, the net worth and liquidity would have started much lower, and then you do the stress test and it takes it down much lower. It does not look like such a strong financial guarantee anymore. It does not look like an
See, this is where the Trump derangement syndrome starts to kick in. It's a typical talking point of the left that Donald Trump isn't as wealthy as he says, because that's what they want, because they're narcissists. This is, they're jealous that Donald Trump is as wealthy as he is, and he shouldn't be. And so therefore, he should have never got this loan and the interest rates and the low interest rates. He should have never got it because Donald Trump's a fraud. He lied about his wealth. He was never that wealthy. And this is what this is why I know, and everybody can spot TDS from a mile away. It is typical. What she's saying is typical of somebody on the left. The problem is she's saying it in the court of law. She's trying to change the standards of justice. It's not like she's some Trump deranged lib on frickin' Facebook or Twitter. She's standing in front of the Supreme Court, the Appellate's court division, and she's arguing this case to lower the standards. That Donald Trump isn't as wealthy as he says he is, and he should have never gotten that loan. It's getting dangerous, man. It's like these are going to have real life impacts on states, on the justice system, and it's a threat. It's dangerous. It's damaging.
Ironclad guarantee anymore. And it was absolutely a fair inference that Deutsche Bank would not have given these loans without the financial strength being inflated. That was also evident from Haig and McCarty testifying about the incredible
Doesn't Mr.
collateral.
Doesn't Mr. Haig testify that there were 14 factors and this was the least important factor?
Well, there were certain.
Mr. Haig, the person he's talking about, the witness, is actually the Deutsche Bank is the lender. And what she's arguing is that Mr. Haig, if he would have known about this or that, he never would have gave Donald Trump the low interest rates. And the witness came out and said, yeah, but you're relying on one metric that we use to loan somebody money. There's 13 other metrics that we use to qualify Donald Trump for the low interest rates. I hope that makes sense. I hope any of this makes sense. I'm just telling you, this is what I watched. I'm just trying to explain to you as we go along here the entire case and what everything rests on. So hopefully it makes sense.
Certainly there are multiple factors that go into the risk assessment, but both for materiality and for disgorgement, the issue is not whether there's only one factor. There's often a lot of factors that are being considered. For materiality, it's whether it's important to the overall total mix of information. And this was absolutely critical to the overall mix of information, not only because they were looking specifically at what the net worth was in order to decide the terms of the loan, in order to figure out whether they would take on this risk, but also the financial statements were coming in each year, and they were important, critical to the loans each year, because Deutsche Bank was reassessing the risk every single year, and it was using...
I'm sorry, but what's being described...
She's trying to say that Deutsche Bank would have... I don't know what she's essentially trying to run Deutsche Bank. Oh, Deutsche Bank never would have loaned Donald Trump the money. But Deutsche Bank came out and said, yes, we would have. And we would do it again because we made a lot of money off Donald Trump because he paid us back. This is why it's so bad to bring a case like this where there's no victim and both sides are happy with the transaction. And then you have the state coming in and saying, yeah, but you wouldn't have been happy if you would have known if you would have known this, you wouldn't have loaned them the money or you wouldn't have gave them the low interest rates. And they're sitting there, you're like, yes, we would have. It's so bizarre, man. You're essentially giving the power of private businesses and private transactions to the state. It's never going to happen. Hopefully it doesn't. But I think these judges, I think they see right through this stuff, man.
Sounds an awful lot like a potential commercial dispute between private actors.
Well, to go back to the first question about whether there's other examples of this, there are other examples of this. In the First American case, the Attorney General brought a 6312 case where the transaction at issue was between a very big bank, Wells Fargo, and a professional appraisal firm.
But wasn't the concern there that the public would ultimately be negatively impacted and affected by what those corporate actors were doing?
And that concern is here as well, because when you have hidden risks getting injected into the market, that hurts the market and honest participants in the market. And the legislature also decided, contrary to what defendants think, that making sure that business in New York stays honest is the way to attract and keep business
So to that
in New
point,
York.
the executive law 6312,
Okay, so this judge goes into the law, once again making the case for Donald Trump. How can the state come in and say they will be the arbiters of what's risky business or what's not? This is what makes this so dangerous. You're essentially handing private businesses and their means to making money, to making business deals, to the state. Because what you're doing is you're trying to say that this was a scam when it's not. The state of New York can't be the arbiters of what's a risky investment and what's not. They can't tell a business what they can sell and what they can't sell. They can't sit there and say, oh, well, you can't give them a loan because we think there's added risk. And the bank, Deutsche Bank or the lenders are like, yeah, we've already calculated that risk. We're willing to take that risk. And because we need to make money, that's our business, to make money. We've evaluated everything. We've done our part, and we're going to lend him the money. And the state comes in and says, no, you can't because you're not thinking about this risk and this risk and this risk. And in the case where the judge with the white hair, the one on the left, is saying, this sounds like a commercial dispute of a private business. So essentially, you're exactly what I'm arguing is you're coming in and you're saying you're going to control private business transactions. I'm telling you, it's dangerous. It's very, very dangerous. This judge is actually going to go into one of the law. It's kind of boring, but I don't know. Maybe the video is too long as it is. We'll see. Maybe I'll edit it.
just want to read a section of it. Well, not exactly, but
she makes a good
was
point.
enacted to promote and protect honesty and integrity. It's the same question I asked the other side. In commercial marketplaces in New York, by stopping fraudulent and illegal businesses. To accomplish this purpose, the statute authorizes the Attorney General to bring civil enforcement proceedings on behalf of the people whenever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transacting of business. I don't read harm or threat of harm in that, but the other side is saying that that is to be read into the statute. Are there any cases where the language harm or threat to harm limits the scope of the Attorney General?
No, Your Honor, not as to liability and not in cases like this where what the Attorney General is seeking is injunctive relief and disgorgement. Greenberg from the New York Court of Appeals and Ernst & Young from this court make clear that reliance by a counterparty and actual harm to a counterparty are not required for liability for any of the claims here.
Isn't that scary? That you can penalize a business for nothing? Really? Just by you claiming that there could have been harm to the public, but there was no harm. And you're going to charge this guy $500 million. You're going to penalize him $500 million. For what? Who lost money? That is essentially the crux. That is what the whole case relies on. It's like, okay, so you're penalizing Donald Trump and you ask yourself these fundamental questions. Well, you're charging him, you're penalizing him $500 million for what? Who lost $500 million? And what the state's case, what the case they're trying to make is, oh, well, the people actually, they don't really know who lost $500 million. This is why they say the number is outrageous. It's, it violates the constitutional rights of cruel and unusual punishment because there was no $500 million damage to anybody. But yet they're trying to bankrupt Donald Trump and say that there could have been, I guess. This is what is so weird. The judge just sit there and read the statute, essentially saying, yeah, you might have a case if there was actually crime committed, if there was actually fraud conducted. But there is no crime, there was no fraud, so where's your case? That is what she said. I mean, that's what she read the statute right out of there. And now the Democrat AG is having to defend their position, and you could see why it's so weird. You don't get straight answers. You can't point to anything that's like, oh, well, she's got a point there. It's very weird. I think they're relying on the emotions of the judges. Excuse me. Do these judges have enough hatred of Donald Trump to make irrational decisions? That is what everything relies in our justice system right now. That's why if you favor Donald Trump and you give him a favorable ruling, then you must be a racist, bigot, Trump supporter, right-wing extremist. And this is what's so dangerous is you're putting all this pressure on judges, and you're forcing judges to make decisions not based off the rule of law, but off of their hatred for one man. That is when stuff starts getting dangerous, and that's exactly what the Democrats, the Attorney General Letitia James and Judge Engoron, they're relying solely on the judges having Trump derangement syndrome in order to rule against Donald Trump. That's what they're relying on because they really don't have a case here. Not from what I can see, just by watching this one video.
And remember to think about the illegality claims as well, because it's not just fraud.
That's
Could you just
very
let her finish the question? Just
So for the illegality claims,
This guy's
look to the
pissed.
underlying penal law provisions. And for something like issuing false financial statements, there's no requirement for reliance. There's intent, and there's
But the thing is, he didn't issue false financial statements. That's what everybody's trying to say. There is no fraud here.
materiality, which was proved at trial. But if someone issues a false financial statement to their counterparty, the counterparty gets it and is not fooled, picks up the phone and calls the enforcement authorities, the crime has still been committed, even though the counterparty didn't rely on it at all.
So that's you're pointing to Ernst & Young, you're pointing to First American. Ernst & Young, you're dealing with the collapse of Lehman Brothers. First American, you're dealing with an action brought against an appraiser who overvalued properties at the behest of a lender perpetrating a scheme to induce unsophisticated consumers into taking out home loans that they could not afford. It hardly seems that justifies bringing an action to protect Deutsche Bank against President Trump.
And what he's saying is, in the cases you're citing, there was actually people harmed. In one case, the lenders, it was complex. You heard it. It led to people getting loans for homes they couldn't afford. And in another case, there was also people harmed. There was a party harmed. There were people harmed in it. But in this case, there is nobody harmed. Nobody was harmed. So you're trying to bring a case where there was no victim, no crime, no harm done to anybody. And that's very difficult. And these judges are calling it out, man. The one guy's pissed.
Which is what you have here. I mean, you've got two really sophisticated parties in which no one lost any money. And that was the point of my initial question. Every case that you cite involved where there was damage to consumers, damage to the marketplace. You've got a scheme to get unsophisticated consumers to take out home loans. You got a collapse of Lehman Brothers. You don't have anything like that here.
Well, first of all, Your Honor, the statute doesn't require that.
Yes, that, they're pretty much basically saying, yes, we know there was nobody harmed, but the statute doesn't require that anyway. So, I mean, it's so bizarre. It's so weird. It's actually quite terrifying to me to know that our laws and there was a saying, and I don't know who said it, but bad cases bring bad laws. So you're setting bad precedent for cases in the future. And if you come out of this with the wrong ruling, and that's why it's important for Supreme Court justices to follow the law and stick to core values. Bad cases bring bad laws. If this case leads to a ruling that's bad, then every case that comes before it, they're going to rely on this one and say, well, you did it here, so that means you have to do it here. That's why it's so important that judges, especially in this case, don't make irrational decisions based off emotions, which is the entire case is relying on these judges not liking Donald Trump, essentially. That's what all these cases rely on. And you got a lot of judges that don't. Judge Engoron, Judge Chutkin, you have Judge Cannon that really was a straight shooter. Obviously I don't know. Is she a Democrat? Is she a Republican? You don't know. She essentially seen and heard all the cases, but she stuck to her guns. She had courage. She wasn't freaking intimidated by the leftist media, and she made a ruling and she dismissed the case. But some judges are not like that. Some judges hate Donald Trump, and that is unfortunate because that's when our justice system suffers. But anyways, I want to finish off this case. Donald Trump's lawyers makes the final case. This is at the very end of this very long video. And he just absolutely destroys it. He just absolutely nails it. Here, check this out.
Thank you, Your Honor. Just pivoting to that last point. Last year, the Attorney General's office was here on the continuing wrong doctrine, making the exact same arguments. This court rejected them and Trump won. And we're hearing the same arguments again, citing some of the same case law that was sanctionable for our attorneys in the lower court. But here we are. Now, I want to point the court to two citations in the summary judgment record that I think frame a lot of the questions that my colleague was asked. At 13865, there's unrebutted testimony in the summary judgment record that at least creates a disputed material fact that President Trump would have got the same deal from Deutsche Bank if his net worth had been as low as $1 billion. In their calculation, it was never below $3 billion. So it's triple the threshold. And the clear testimony is the interest rates would have been the same. He would have been they held up a chart that would have been on the same pricing chart. So this notion that there were these 8 basis points at issue is just not supportable. Secondly, at 20,042 to 44 of the record and in other places, the Deutsche Bank witness said, we independently assess all these valuations. We are not relying on the numbers that the client is giving us. We do our own independent assessment. That is our due diligence. That's the understanding of the relevant marketplace.
I'm sorry, sir, but
Nordbank.
So we're talking now about cause of action number one, the fraud under 6312.
Yes, and the causation argument as to disgorgement. Yes.
Okay.
Yeah.
So we know point taken, as to the liability on cause of action number one, we know fraud under 6312 has a much broader meaning than common law fraud. And so there it's, as your friend pointed out, the standard is the capacity or tendency to deceive. Did those statements have the capacity to deceive?
Absolutely not, Your Honor, for at least 3 reasons. First of all, they're gap compliant. They're not misrepresentations. All the key things they point to is this was wrong and this was wrong. The unrebutted testimony, certainly in the summary judgment record starting at 17,916, is this is what you do in a financial statement. You are allowed to do this. You are allowed to predict, for example, that you'll get your rent restrictions lifted or you'll get authority for, more units at Aberdeen. You're allowed to do that. You're allowed to make optimistic projections. You're allowed to disregard appraisals. What Professor Bartov said is that appraisal could be sitting on your desk and you don't have to rely on it. And there's actually really powerful evidence in this case to show why that's true. Because if you look at 40 Wall Street, they said, in 2011 and 2012, the appraisals of 40 Wall Street were at 200 to 220 million, and you said 527 million. But they overlooked that a couple of years later, Cushman revised its appraisal and said it's worth 540 million, virtually matching what we had said, and they say is
this guy's good.
So it's kind of these astonishing issues. It's very similar to the valuation of Mar-a-Lago as $18 million based on a tax assessment. It's preposterous. It's a preposterous position that these factual things. So that's my first answer to that. But secondly, more importantly, we have sophisticated counterparties, as a lot of the questions pointed out. They're getting clear disclaimers. The disclaimers say what everybody already knows you do in this industry. You do your own due diligence. So how is there a capacity or tendency to deceive when you have these very clear disclaimers saying considerable judgment is required here. These values don't reflect what might be realized upon a sale and so forth.
But what about the Attorney General's point that may be true in this case, but we are trying to create a fair and honest marketplace, which will inure to the benefit of the public in the long run?
Yeah, and I would say 2 things in response to that. First, all the questions about line drawing, if this case falls on the other side of the line, there is no line. I mean, you heard, I think for 15 minutes, respectfully, my colleagues struggle to articulate any clear principle that would put any transaction outside the reach of the statute on the Attorney General's very broad and sweeping view. So our position is narrow, which is that on the facts of this case, all these things I've referred to, no reliance, no materiality, Deutsche Bank saying we would have given them the exact same deal, and we have clear disclaimers. Surely this is not within the statute. And if this is, there's nothing that falls outside of the statute. And that is a sweeping and unsettling thing. The second point I make.
So basically what he's trying to say is just what I said earlier. If you make this case the case where you draw the line, then you're essentially, there is no line. The state of New York will essentially have broad sweeping powers over complex transactions between two private parties and business transactions. You want to set the limit. That's essentially what they're doing. Supreme Courts are there to set the standard for what, that's what they're there for, cases that are unheard of, unprecedented. They're like, okay, we're going to hear this case and then we're going to set the standard. This ain't the case to do it. If you want to set a standard, you want to draw the line, don't make it this one. This is essentially what his lawyer said, and it makes sense. It's a bad case, and bad cases bring bad law.
About that is.
And I'm sorry, just to tie a ribbon around that, do you mean based on the facts as they were adduced on the respective records, the summary judgment motion as to cause of action 1, the trial record as to 2 through 7? Yeah. Not that the AG didn't have an interest, at least at the outset, in investigating and maybe commencing the proceeding.
We're not disputing that in this.
They certainly have that interest.
You're saying once you got all the facts before the court, which
that may have been, I wasn't on that case, but that may have been the point of our prior decision, which Mr. Isaac brought up, about this being at the pleading stage. Yes, so it was enough at the pleading stage, but at the end doesn't mean this is what should happen.
That's exactly right. You're right.
Yeah, I think they're going to turn this case over. Essentially, what I got from that was the Attorney General had every right to look into this case. They had every right to bring a case. They had every right to accuse Donald Trump of fraud and go through the process. But once you get to this point, it's a completely different ballgame, because once you know the facts, once all the facts are revealed, that's when you're supposed to say case dismissed. There's no case here. So, in other words, the Attorney General had every right to go and look into Donald Trump and look into this fraud case and bring it as far as they did. But that's where it ends. Once all the facts are revealed, once the judges and everybody sees what actually happened, that there was no fraud, there was no crime, that's when it's supposed to stop. But it's not, because these people are trying to interfere in an election. They're trying to kneecap Donald Trump because they don't like him, because they have Trump derangement syndrome. And so they want to bring the case on forever and ever and ever and ever. They want Donald Trump to pay, even though there was no fraud. They want to create fraud, and this is what they want to do. This is what they've done for every single case. And let me just go ahead and finish this. Let's finish this real quick.
Here we have all the facts before the court.
But the pleadings in this case, but the pleading in this case is like a novel. It goes on at length, 327 pages or something like that. And basically, those were the facts that Justice Engoron found were proved at trial. So aren't we bound by our prior decision? I asked this question in another way before.
Very significant variations. I just want to flag one. I see my red light is on. The pleading, the complaint, cites GAP like 50 times. They said these statements are bad because they violate GAP. But you go to the summary judgment record, they have nothing. They don't put anything on GAP. The trial court never cites GAP. Our experts say these are GAP compliant. That's unrebutted. So there's this the record looks totally different once all the facts are in. And I know my time has expired, so I thank the court for its time.
Thank you.
Your Honor, I'm actually going to go under my time. I just have one observation, and I don't know, maybe I'm wrong about this, but this argument, if it doesn't show why not making a summary judgment motion was appropriate, I don't know what is. There was absolutely nothing wrong with what the attorneys did. My adversary said that she's relying on the Ernst & Young case. I read to you what you said. That's exactly what you did. One more point and I'll sit down. Keep relying on Greenberg. This is what the Greenberg court said, Greenberg 2. Initially.
All right, so that's pretty much the end of it. There was one more that I actually wanted to play. That's pretty much the end of the case. And, you know, they leave after that. But it just goes to show, personally, I think all of these judges, and when you look into, let's go back to this article. When you look into the article, I'm pretty sure all of the judges have to rule the same. Trump is asking the court to reverse Judge Engoron's ruling that Trump lied for years about his wealth and paperwork given to banks, insurers, and others to make deals on secure loans. The verdict cut to the core of Trump's wealthy businessman persona. That is what they're trying to show. They're so jealous of Donald Trump. They hate him so much that they want to prove to the people that he's not as wealthy as he said he is. They do this stuff all the time. You guys remember the taxes when they came out and said Donald Trump doesn't pay taxes, Donald Trump doesn't do this, and then they finally got a hold of his taxes illegally, by the way, and that person actually got arrested and I think is sitting in prison right now for leaking his tax documents. But they're doing the same thing here. They're trying to prove that Donald Trump isn't as wealthy as he says he is. And all that's going to happen is Donald Trump is going to be vindicated. And that hits at the core reason why I wanted to make this episode. What's going to happen, and just like I said was going to happen months ago, every single one of these cases Donald Trump is going to be vindicated on. So, in other words, after the election, it's going to come out that, yeah, Donald Trump isn't a felon. The entire mission of the left was to get Donald Trump the name convicted felon so that they can go out there with their slogans and convince people, oh, how could you possibly vote for a convicted felon? A convicted felon should not be sitting in the White House. He is not fit to run office. Convicted felons can't be president. And then after the election, everything's going to come out. All these cases are going to get turned over and reversed and appealed. And it's going to turn out, well, he actually isn't a convicted felon. And it's like, oh, well, I guess we got what we wanted. So like, that's what I fear is going to happen. And I know that's what they're doing it for. Because they know these people are not dumb. They know Donald Trump did not break the law. They know Donald Trump did not commit fraud. They know Donald Trump wasn't cheating on his taxes. They just use these things to trick people. And then after the election, it's going to come out, okay, Donald Trump actually didn't do anything wrong. But the election's over. So they're using it for talking points, for slogans. But I think this verdict is actually going to come out before the election, and which would be a good thing because it would prove my theory right. And I think it would really hammer down this notion that Donald Trump is a convicted felon. I think it's really going to challenge the idea that Donald Trump is this convicted felon and isn't fit for office. Donald Trump did not attend the hearing. In the past, he has decried the lawsuit's outcome as election interference. It is, because they're using it as election interference. They're using it to say Donald Trump is a convicted felon. That sways people's minds, man. That changes people's minds. When you go up to somebody and say, oh, how can you vote for a convicted felon? Someone's like, oh, he's a convicted felon? Really? They're like, yeah, man. Can't you see all these cases? The guy's been convicted of felonies. And then they're like, oh, wow, I guess, I can't vote for a convicted felon. I guess I'm not going to vote this election. That's what they're doing. That is election interference. So they're using the law to give Donald Trump the name convicted felon so that they go out there with slogans and convince people, how can you vote for somebody that's a convicted felon? And then after the election, they're going to be like, well, he's not actually really a convicted felon. We just kind of used the law to give him that name so that we can win an election. That is election interference. It's like, so Donald Trump is right. They are interfering in the election. So the appellate division typically rules about a month after arguments, meaning a decision could come before the election day. The court could either uphold the trial verdict, reduce or modify the penalty, or overturn Engoron's verdict entirely. A majority of the 5 appellate judges from Thursday hearing must agree for the judgment to be altered. Okay, so it's not all of them, it's just a majority. I read that wrong. So there you go. I mean, obviously, here's a video of this girl getting steamrolled. I don't know if this is something we watched here. Let's just check it out anyways.
The immense penalty in this case is troubling. So how do you tether the amount that was assessed by the Supreme Court to the harm that was caused here, where the parties left these transactions happy about how things went down?
Well, disgorgement, Your Honor, looks at taking the gain away from the wrongdoer. And although this is a large number, it's a large number for a couple reasons. One, because there was a lot of fraud.
See? So their whole case relies on, there was so much fraud for so long. That's why we have to charge him $500 million. And even the judges are like, oh my God, like, don't you think that's a little much? How can you prove that there was $500 million in damage? And what the Democrats are arguing, what the Attorney General's office is arguing, we're not going off of the damage Donald Trump has done. We strictly want the money Donald Trump would have made from all these fraud business deals. So essentially, they want to bankrupt him. They feel like Donald Trump has not deserved, he hasn't deserved the money that he's earned. And so we want to take that money from him. It's a very scary stuff, dude. It's very authoritarian, but it's not surprising. This is how Democrats are. They are very authoritarian in nature. This is why they are the party of censorship. This is why I won't vote for them anymore. I don't like where the Democrat Party is going, and frankly, it's quite terrifying. And in every instance and through every empire and every country that's ever evolved over 250 years, there's always one party. There's always one side that wants open borders, like in ancient Rome. That's how Rome fell, one of the major reasons. There's always one side that wants to censor the other because, obviously you don't want to censor people if you're telling the truth. Only the liars want to censor people. And so, like I said, there's always parties in every empire, throughout every country, throughout every nation, throughout history. There's always one side that brings on this kind of dictatorial nature. There's always somebody that wants to control what you drive, control what you eat. Oh, we have to do this in order to control the climate on the planet, all this stuff. Instead of they don't believe in individual liberties and freedoms. They don't believe in conservatism. They don't believe that the Constitution is a document that should not, that's not, they don't believe the Constitution is a document that's up to date. It's out of date. It should be thrown out or disposed of or changed altogether. The courts need more judges. Like, this is what they do. They're progressives. They progress a nation into extinction, essentially. This article is very big. I will post it in my podcast description. Trump posted a $175 million bond in April to halt collection of the judgment and prevent the state from seizing the assets while he appeals. Think about that. $175 million. If they draw the line here, there's going to be a lot of businesses out there that are going to be threatened by this ruling if this is allowed to go through, which is why I don't think it's going to be allowed to go through. If either side doesn't like the outcome, it can ask the state's highest court, the Court of Appeals, to consider taking the case. Trump has vowed to fight the verdict all the way up to the U.S. Supreme Court if necessary. I don't think it's going to get that far. I think it's going to stop right here in this courtroom, this appellate court in New York. I don't think any of these judges are buying what the Democrat Attorney General is selling. I just don't. Even right here, it says some judges in a New York appeals court appeared receptive Thursday to possibly reversing or reducing a civil fraud judgment to stand cost Donald Trump nearly $500 million. One judge called the former president's penalty troubling. It is troubling. $500 million is troubling. And if for there not to be any crime or fraud or anybody hurt or any harm done, that's a lot of money. It's actually terrifying. So I can tell you right now, the judges I think that are going to go with this, it's going to be this one, this one, this one, and this one. But then again, this one too cited law. Basically, the law that she cited, she was like, well, the statute itself says that there must be harm, and you haven't proven any harm. Essentially is what she said. That's what we played in the video. So, man, I'm telling you, I don't think this is going to make it all the way. I think they're going to reverse this entire thing, and that will be another case. So that'll be two cases of Donald Trump that have been reversed. And if you base those two cases, if you apply that pattern to all of Trump's cases, in the end, Donald Trump is going to be vindicated of everything. All these cases are going to be reversed. I think the January 6th case is going to take forever because it's a federal court, Jack Smith. But if Donald Trump wins, it's over. It's done. But here's the thing, though. How do you prevent this from happening again? Because that's exactly what we need to do. This should never, ever happen to anybody ever again. And the only way to do that is by holding these people responsible. Letitia James, Judge Engoron, Judge Chunkin, everybody involved in this conspiracy to interfere in a federal election by weaponizing the justice system should be sanctioned, should be disbarred, at the very least be investigated for their collusion efforts to try and interfere in a federal election, violating people's civil rights, the right to vote. People should not be swayed by a justice system. They should not be swayed by the federal government why they shouldn't vote for Donald Trump. You know what I mean? So the federal government can't come in here and be like, oh, well, we got to figure out how to turn this guy into a convicted felon so that we can convince voters that they shouldn't vote for him. Like, you can't do that, man. Like, that is interfering in the people's elections. The federal government's supposed to stay out of it as much as possible. You can't use the tools and weapons. You can't use the tools and tactics we gave you as voters to, you can't use the justice system to kneecap a political opponent because you don't want to see him as president. That is so wrong, and it's something that should not only be rejected, but somebody should pay the price for even trying it. Because if these people don't pay the price, If there is no penalties for this, then they're going to do it again. I say that the only reason these people are doing this is because nobody paid the price for Russia collusion. No FBI agent. I think there was one that got probation or something and suspended his bar license. Like, nobody was held accountable for Russia collusion hoax, and so therefore they keep trying it again and again and again and again. If all these people are not held accountable, and I'm talking judges, I'm talking lawyers, I'm talking everybody. If they're not held accountable, sanctioned, or disbarred, or at the very least investigated to see if there was collusion with the federal government in between these states, to see if Donald Trump to see if they actually colluded with one another to try and convict Donald Trump or use the justice. If none of these people are held accountable, then it's going to happen again. So these people must be held accountable. This cannot ever happen again, because this is the type of stuff that destroys democracies. This is the type of stuff that destroys republics. These are nation-ending tactics here. This is the exact type of stuff that ruins a country. So I watched that entire clip yesterday, and I wanted to share it with you because I thought it was amazing. But this video has went on long enough. I'm going to be getting back on here in a minute to just do like a little short clip. For those of you out there wondering, yes, we did survive the hurricane. Hurricane Milton passed us with minimal damage. Unfortunately, 4 people in my town died. There was 160 tornadoes that touched down in 24 hours during that hurricane. It was by far a record. They said they've never seen anything like that before, and that's actually what was killing people. It was 160 different tornadoes dropping down, wrecking stuff, wreaking havoc, and then going back up 160 times. We didn't get hardly any rain. The back of my fence is completely destroyed. It's better now. I put it back up. I got minimal damage. We didn't even lose power here. There was like a lot of people that lost electricity. I got hardly no sleep at all. God was looking over us, man. We wear the armor of God right now. So we said our prayers, and we prayed for the families that did lose loved ones. And that's what we did, moving on to the next. I put my storm shutters up for the first time. I had a bad feeling about this hurricane for some reason. It was the first time I put up my hurricane shutters, which was a pain in the ass. That took like freaking hours and hours. And I'm going to leave them up for a little while, and at least until hurricane season's over. So, all right, ladies and gentlemen, as always, thank you for tuning in. If you want to support the podcast, you could follow the audio version of the podcast on Apple Podcasts and Spotify. If you want to support the show on YouTube, smash the like button. And most of all, no matter what you do, just share the episode with your friends and family. Get the word out there. Obviously, shows like this, conservative content, does not get the algorithm boost, or they're not throwing this show around quite often. So, unfortunately, telling the truth these days is a lot more difficult. So what really helps is just sharing the episode with your friends and family. That actually just get the word out there. Like modern day Paul Revere's, it's our job and duty as American citizens to inform our fellow citizens so that they go and get involved in our politics, because that's how democracy works. And it only benefits the people when the people are actually involved and doing their due diligence and researching candidates and looking into these issues. And so that's what I'm here for. That's what I do. I enjoy doing it. And I'm going to continue doing it forever, as long as I can, until they deplatform me. So, yes, sharing the episode with your friends and family, that's how we do it. And yeah, if you want to get a hold of me directly, get a hold of me, StephenTorrielloShow@gmail.com. And again, thank you so much for tuning in. God bless you. God bless America. And long live the Republic. You guys have a good one. Bye-bye.